When parole rewards participation, what victims are not told. Why victims are confused and why offenders are not. What I'm about to explain happens across the country every day. Parole rewards offenders for participation. Participation like classes, programs, boxes that need to be checked, while victims are left out unless they fight to be included. In Texas, one example of this is Senate Bill 676. Hi, I'm Sarah Raney. Most of you know me as Mama Bear. A repeat drunk driver killed my son, Dr. Kenley Gene Raney, and 7 years later, the system is working to move him toward parole. My son never had a DUI. He never hurt anyone. He spent his life helping others and became an emergency room doctor. I'm not here as an attorney or a politician. I'm here as a mother who learned that after conviction, victims are expected to be quiet, while the system keeps helping the offender. They thought silence would finish me. I'm a mama bear, and this isn't over. Before victims can understand parole, we need to be clear about one thing. Offenders know how to work the system, paid for by our tax dollars, while victims are left to fight alone. Fed promises, sent to impossible websites, and given no real support. To the parole board, participation is just simply showing up and doing what's required so the paperwork looks good. It's taking classes, joining programs, attending religious services. All they have to do is go in and sit down and pretend like they are enjoying it or learning something. It creates a record that sounds positive in hearings. Sounds great, but participation does not mean owning the life that was taken. It does not mean accountability. And it does not undo the damage families live with forever like us. A mama bear knows the difference. The parole credit I am talking about comes from Texas Senate Bill 676, filed during the 89th regular legislative session. Internally, it is tracked under a draft identifier most victims will never see or understand. 89R2842BCH-D. That alone explains part of the confusion. Texas SB 676 amends Texas Government Code Section 493.003, which governs good conduct time. This change applies to people already incarcerated and takes effect of September 1st, 2025. Here's what Texas SB 676 does not require. Does not require accountability, acceptance of responsibility, acknowledgement of harm, victim notification, victim input. This is why victims are so confused. If you've been through discovery and trial, you already know this. Each agency handles its own pace, barely communicates. Let me say that again. Barely communicates. In my experience, I find that they never communicate. The people that you are talking to or trying to get information from, they know what they are doing, but they have no idea what other agencies are doing. They just spout off and tell you what they themselves have Googled, which only confuses the situation. Again, I will say this. Communication between agencies is limited. Victims are left to connect the pieces on their own. In Texas, that can mean dealing separately with the district attorney's office, trial and sentencing, victims assistance or victim services, if you're lucky enough to be assigned. I am still waiting for my liaison to call me back. The Texas Department of Criminal Justice, TDCJ, the Integrated Victim Service, IVSS, which is very important, VINE, Victim Information and Notification every day. Now do understand these are Texas. Every other state has different ones. and Texas Board of Pardon and Paroles. This is the one that I'm working with right now. I break this down in my videos, what each agency does, where victims are sent, and what actually happens, so other victims don't have to navigate this blindly. It is confusing, very confusing. Like I said, each agency handles only its piece of the progress. No single agency walks victims through the whole picture. They don't even know what the whole picture is. They only know what they can do or what they're trained to do. Offenders are guided at every step, and we pay it for it. Victims are left to figure it out all alone. Sometimes without even being told where to look, which happened to me. I was never told where to look. Like I said, I'm still waiting for the liaison to contact me after calling them several times. That confusion is by design. They want us to be confused. Criminals are supported at every step, and again, we pay for it. Victims have to fight like Mama Bear just to be heard. This is not just Texas. SB 676 is a Texas law, but this problem is national. Every state has parole systems that reward participation, rely on discretion, and quietly move cases forward. Different names, different statutes, same results. The system protects and moves the criminal forward while victims are left confused and devastated by how we are treated. Final truth. Across this country, participation is rewarded, accountability is softened, and families like mine are left serving a life sentence of loss. This is not justice. This is parole power, operating without transparency and without victims at the center. Stay informed, register, ask questions, participate, because your voice only exists in the parole process if you use it. Parole moves forward on the timeline, not emotions. Victims must stay involved to make sure their voices are present, heard, and considered. Typically, you have to start a year in advance. Don't believe anything is automatic. Register everywhere you are directed. In my case, I was not directed anywhere, so I found the list of different portals that you need to go to get help and to register. And I have listed them in the description of this video, as well as posted them on my YouTube channel. Ask questions repeatedly. Document every call, every name, and every state. Now, be mindful of state laws if you choose to record calls. I'll be honest with you. What I did was this, because I could not trust the information that I was getting from the DA's office. I did record them, but I did not let on that I recorded them. I made sure that I had them so I knew that I had the correct information. In theory, victims like me are supposed to have a liaison in the parole phase. Now, I have been calling the Department of Justice and to be able to get a liaison, because they do not tell you about them. You have to be proactive and contact the Department of Justice. Or victims' rights. Now, victims' rights person would be the one that handled it before parole, had it during the trial and discovery phase. That is what we are told. But in reality, like me, many of us are left in the cold, sent to chat boxes. I dread chat boxes, unanswered emails, disconnected phone calls, and confusing government websites, even years later during the parole phase. That is why this channel exists. This space is for victims and mama bears. Navigating a system after discovery, trial, and sentencing without clear guidance. I share what I've learned the hard way in everyday language from lived experience, so other victims don't have to fight blindly. Most victims trust the system to do its job. But when you speak up, ask questions, or demand accountability, you learn the truth. The system will resist. That's when you realize why mama bears have to fight. I'm doing this out of a mother's love for my son Kenley, and for every victim who refuses to be silenced. Until this system truly includes victims, mama bears have to help each other. This is where victims learn from other victims. Information is power. Silence lets parole move forward. If you are a victim, subscribe and share your story so others can prepare and protect themselves. When victims speak, mama bears stand together. Thank you.